Good afternoon, sir.
Good afternoon, CJ.
How do you pronounce your name? I'm avoiding mispronouncing it.
Thupaatlase.
Thupaatlase.
Yes.
Thank
CJ.
you.
Thank you.
Thupaatlase.
I know it's always difficult. That's why they only call me TT, CJ.
I can't call you Mr. T T now, can I?
Yeah, no, not today, not today.
You studied BUris and LLB degrees
That is correct,
at
CJ.
you obtained the BUris at that university that used to be known as UNIBO.
Yes,
And then you did the LLB through UNISA.
through UNISA, CJ.
Was that while you worked as a public prosecutor?
Yes, that is the reason I worked as a prosecutor, DJ. And subsequently a magistrate.
Oh, yeah. So you were a public prosecutor for 4 years, about 4 years?
Yeah, about 4 years, 1985 to 1989.
Uh-huh.
That's correct.
Then joined the magistracy.
That's correct, CJ.
And you were there for about 14, just over 14 years?
Yeah, just over 14 years until 2005, CJ. Then I resigned.
You went to work for, was that the private sector?
The Universal Service Agency, CJ, is an agency of the Department of Communication, what is now called Department of Digital Technology.
Oh.
It is created in terms of, in the Electronic Communications Act, there is a chapter that deals with universal service. So the Universal Service Agency administers the fund that is created. The Act provides that a certain percentage of every licensee is obligated by law to contribute towards that fund. That fund is called the Universal Service Fund. It is a fund that is supposed to be tapped by the same licensees, your telcos, when they go into rural areas, the idea being that with a recognition that in those areas, from a commercial and a business point of view, they may not make money. So as a result, then when they want to expand electronic or telecommunication infrastructure in those areas, then they are required, then they can tap into that fund. In addition to that, every licensee telco in the country has what we call universal service obligations. And those obligations are also then monitored by this particular agency, the Agency of Department of Communications. But it has a separate board, it has a CEO and all that. But I was only there for 18 months.
Yeah, as if you were in the Legal and Corporate Affairs Department.
That is correct,
Giving them legal advice.
That's correct, CJ.
Well, I doubt very much that my village has ever benefited from this body.
Yes, CJ, you know that it's one of those things that on paper they look very good, but the implementation is always a challenge.
Something else, yeah. Then you left them and joined Neotel.
Yes, Neotel at a time was just been licensed. It was envisaged that it was going to be what was then called SNU, a second national operator. And the minister licensed it and I worked there. It also, as I've indicated, also had those obligations. So the idea was I would go there and we started the department, community service that was to deal specifically with those universal service obligations. I was not strictly within the legal, there was a separate legal department at that time. Yes.
But then you went back to the magistracy.
CJ, yes. You know, for the first time in my life, there was a point I was not working. What happened is that Neotel did not really get off the ground to become a successful company, and at the end of 2010, we were offered severance packages. I decided to take that, and I was home from January of that year until June when I applied and for an acting position, and I went and worked for a year in Klerksdorp. During which period permanent positions were advertised, and thereafter I applied and I was successful. I went to work in Bloemhof, so as a head of office and the only magistrate in that district, doing both Bloemhof and Christiana.
So you went back to the magistracy and never left?
Since 2012 to date, I never left again.
And you've worked your way all the way up to regional magistracy?
Yes, I must appreciate the considerations that the department gave me. I think my past experience was never ignored whenever I had applied. So as a result, I became a senior magistrate for Krugersdorp and then acted as a chief for 5 years in Randburg. And then since last year, I'm a regional court magistrate in Soweto, Protea.
So you've been a magistrate for about 27, 28 years?
That is correct, CJ.
Running the criminal and civil court?
Yes, CJ.
Various stages.
Various stages, but especially, let me say, when I worked in Garankuwa, at one stage, just on my own accord, I decided that I wanted to do civil work. At a time, they still had what was called Justice College when they trained, and from that moment, the bug bit me, and I've been mostly in civil work, which of course then, and the experience came very handy when I was the only magistrate in Bloemhof, because then I had to do everything.
Yeah, and that experience paved the way for you to be appointed to the Rules Board.
Yes, CJ. Yes, CJ, to the Rules Board, yes.
And you list subcommittees in the small claims and magistrates court in which you've sat.
Yes, and also the cost committee, subcommittee. The Rules Board operates with subcommittees. Each subcommittee does a particular work, and then of course there is a meeting of the whole Rules Board, chaired of course by a judge from the SCA, presently Justice Ndambuza.
Yes, and you train aspirant and serving magistrates under the auspices of the SAJE?
That's correct.
You have acted as a judge?
Yes, from third term of 2021, fourth term of 2021.
2023?
2021.
Sorry, 2021?
Yes.
And for how long were... No, it was not just one stint, was it?
Yes, in 2021, I acted for a full term. In 2022, it was also for a term. And it was for 2 terms. And then in 2023, I acted also on the 4th term.
Was your last acting stint in the High Court in 2023?
2023, last term.
And you claim to have presided over civil and criminal trials, opposed and unopposed motions, family court, criminal appeals.
That's correct, CJ.
And road accident fund matters.
That's correct, CJ.
Did you produce any written judgments?
I have I have counted about 40 judgments during the 37 weeks that I've acted.
Yeah. Have any of those been reported?
No, CJ, only published.
In SAFLI?
In SAFLI, in JDR. I know the CJ will ask me why I didn't mark them reported, but in a majority of cases there, I said, the consideration was always, I was confirming principles that higher courts or courts with more than one judge has dealt with. So I've never thought it wise that there was anything novel that any of those judgments produced.
Well, experience has shown that it is not only judgments on novel issues that may be useful, especially to the, to the lower courts.
Yes.
So if you've spent a considerable amount of time and did good research in the subject area you covered, if it's good to mark it reportable. You can sense when a judgment is reportable. Then it's up to the publishers to ignore it if they don't think it's worth publishing in their books.
I appreciate and accept the advice.
We've lost a lot of good judgments because people don't mark them reportable.
But on the same breath, with the present digital publications, much as they may not be reportable, I take that they are available to be considered.
Yeah, it is easy for people to pick them up.
Yes.
Okay. I'm going to give Judge President Mlambo a chance to ask you questions.
Thank you.
Thank you, Chief Justice. Good afternoon. Mr. Thupaatlase.
Good afternoon, JP.
Did I pronounce it correctly?
You have, JP.
Thank you very much. I know you told me that it's been a painful wait for you. We apologize for that.
Yes, but I also added that, it's the first time that I've been ordered food when I came to an interview. Thank you for that.
Yes, you did say that after a number of times applying. Or it's the first time to apply?
No, it's the first time.
First time you apply, yeah. So you must have a magic wand to apply for the first time when you are shortlisted. My spreadsheet says you've done 37 weeks totally acting.
I agree with it.
You agree with it? And all of those acting stints have been term long.
They have been term long, see.
Yeah, and the reason they've been term long, you're able to do that because you're a magistrate, you are able to arrange your life accordingly.
Yeah, especially when I worked as only the head of office, chief magistrate of Randburg, because
yes.
I was not doing full-time court work, so that became possible.
Yeah. You, in your capacity now as a regional magistrate, you do a lot more criminal work than civil, am I correct?
That's correct, CJ.
Yeah.
There is an element of civil work, but it's so little that, in fact, we have just allocated to one magistrate.
Yeah.
So the idea is that from time to time we'll just alternate, but as it stands, only one magistrate, so I do only criminal. And I can tell you it's hard in Soweto.
I know, I've been there. But here's what I want to suggest, Commissioner Gottsel has been raising the issue of the long lead times in Gauteng. You've acted in the High Court. You are aware that quite a big number of the matters that come to the High Court, especially in the unopposed motion roles, belong in the magistrates' courts.
That's correct.
Now, are you going to help us find ways of lawyers taking these matters to the magistrates' courts? Because they actually don't mind. Even if they come to the High Court, you don't give them High Court costs, they still come to the High Court.
JP, I sat with you in PEC meetings. I know the discussions, what went on. I know what motivated you, for instance, to constitute a court that ultimately produced Mugabe's decision.
Well, it produced a decision I don't like, but anyway.
Yeah, despite all the best efforts, for instance, by the South African Human Rights Commission to take the matter to, it was the wisdom of our highest, the apex court, that such matters can still come. I was just rereading the judgment yesterday, telling me that, in fact, the court, the High Court, for instance, cannot refuse a jurisdiction to entertain a matter. But having said that, the rules board, considerations are always given, for instance, around the issue of what can be done. We introduce, for the High Court, we introduced Rule 41A. I think it's a rule that needs maybe to be revisited, and maybe just to make it have teeth, because it has become apparent from me, at least, that it is just becoming a ticking box for lawyers.
It's a tick box.
It's a tick box. Practitioners just tick that the matter cannot be mediated, as a result of which.
No, look, you don't have to go further.
Thank you.
That's not why you're here.
Yeah, thank you.
Yes, this SCA and CC judges
That's there.
live in a different planet. Do you agree with me?
Oh, difficult to say.
Don't agree with me.
No, I don't.
I'm just saying that.
Yeah, no, just I want to leave it to you.
Yeah. In your acting stints in Gauteng,
Yes, JP.
you've done 3 weeks of opposed motions,
That's correct, JP.
as well as 1 week in the agent court,
That's correct, JP.
and no allocations in the special motions. Right. And those are, especially motion court, opposed motion court, it's a difficult work area. And I told you before you went there that...
You told me so, JP.
Yeah.
And in fact, it's interesting that, I started when because of the COVID
Yes.
restrictions, so I was essentially all by myself.
Yeah.
I had to do most matters online, but I'm happy to say I think I acquitted myself well.
No, you did. You did, yeah. And in the course of you acting, you produced some 40 judgments.
That's correct.
That's what I have here. Now, what I've noted is most of your judgments are within a month to 2, but there are a couple, I think I marked 4.
That went beyond.
That went beyond the 3 months. 1 is 5 months, 2 are 4 months.
Yes. In particular, the 5 months one, JP, it involved medical negligence.
Yes.
It was what we call long duration trials of 10 days, and it lasted 10 days.
Yes.
Both the plaintiff and the defendant each had 5 witnesses on each side.
Yeah.
In addition to evidence witnesses that were called. So it really needed more time for me to consider, and I considered that.
Yeah.
And that is the rest of the other cases, and I know I received a call from you on a Sunday, JP, or on a Friday, but it was on the 26th of January when you were alerting me to a judgment, a TIPCON judgment, and I said to you it was ready. And by Monday I had delivered that judgment. The idea here is that I type my own judgment, I do my own editing. So at times, maybe out of self-deprecation, I tend to take longer, maybe just to once always read. Every time I read, there's a comma that I need to add or extract it. But end of the day, but the task, and I'm aware, in instances where I went beyond 3 months, I profusely apologize for that, and it is mainly because of also the work. You'll realize most of those cases are the ones that when I was now already in the regional court. And I've told you that the regional court in Soweto also breaks the back. It's like we are in Johannesburg High Court.
Yeah.
Yes, JP.
Now, we had a magistrate here, senior magistrate who appeared, who confirmed that your experience as a magistrate's court magistrate on its own does not equip you to take permanent appointment in the judiciary. He said that's correct. What's your view of that?
JP, I don't think I agree that it doesn't. Because at the end of the day...
I'm talking permanent appointment.
You mean?
Permanent appointment as a judge.
As a judge.
Yeah.
That experience coupled with the acting,
I didn't couple with.
or with not coupling with.
Yeah.
Yeah. Yes. If I just have to come to the magistrates court
Yes.
and right into the high court, I believe there could be.
You need to act.
You need to act. Yes.
Now, you've had the bulk of your experience as a magistrate,
That is correct.
senior magistrate, and you were in Randburg before you came to the what do you call it, the regional court.
Yes, yes.
But you've only been there a year, or just over a year.
The regional court.
Yes.
Yes.
Yeah. So this is a question I ask you. Why do you want to come to the High Court? You've just been there a year. What motivates you to want to then come to the High Court directly?
Oh, direct. Well, JP, the regional court is just a specialist court in terms of criminal work. The overall, to be a complete magistrate, if you're a district court magistrate, to me, makes a more complete magistrate, because all aspects of the laws or the areas of the laws, family, civil, criminal itself, are dealt with in that court. We know the history where the regional court comes from as a court, as a specialist criminal court.
No, but the regional courts have civil jurisdiction.
Yes.
Why don't they do a lot more civil work than they are doing criminal work?
JP, the reason that I can think of, and I've heard practitioners talk about,
Yes.
is lack of experienced magistrates. Because when it was introduced, the bulk of the magistrates only had criminal experience. It is, of course, now that the Magistrates Commission is trying very hard to widen up the pool in terms of attracting, especially people from the members of the bar and the sidebar.
Yeah.
So,
Okay, but I'm not blaming you. I'm just saying that's the dynamic we see at PEC trials, that the work that comes to the High Court should actually be done in the regional court.
in the regional court, I agree with you entirely.
We would not have these long lead times if that was happening.
Yes, but it is one of those things that must be encouraged. But remember now, JP, the law as it stands now, the interaction is between the magistrates court and the High Court. I've tried to look both at the rules and the act itself. The only time that a matter can be transferred, for instance, from the High Court is to the magistrates court. So maybe those are, with the powers that be around this table, is something that can be legislated. And then,
No, the minister is here.
yes, then that can be legislated. And,
Yeah.
and
So,
see.
just my last question. I'll come to you about my scoring matrix. Don't you think you could have done more in the acting stints, especially in coming for more acting stints to be allocated special motions to see how you handle them before you availed yourself? No? Because you've not had a special motion allocation.
Yes, I've not had a special motion. My general experience, JP, and I know the approach that you take, that one must have been exposed to all forms of the work. But my general,
The difficult work.
the
areas.
difficult work.
Yes.
Yes, but I've handled urgent court. I've handled opposed motion. So if I have to have an opportunity of doing a special motion, I do not see how I will be unable to deal with it.
You see, because when I look at your spreadsheet,
Yes.
you've only sat in one full court appeal. I don't know whether you wrote it. And
Yeah,
then,
I wrote. Yeah, it was 2 matters. One was written by another senior judge, and I wrote the matter. The average case matter is the one
Yeah.
I said.
And the numbers of the work you've done as an acting judge compared to other candidates who have sat there is quite low because they've acted longer. And I mean, civil trials, you've only handled 2, right? So that's why I'm asking whether you think, like in Asian court, you've only done 1 week. If you've done 3 or 4 weeks, I would understand. So that's why I'm asking whether you think you are ready, I should recommend you, or you think you could still benefit from more acting stints.
JP West said, I think I'm ready.
You don't agree? No, look, I'm not intimidating.
Yes. No, I agree with you, JP.
Okay. CJ, I don't have any further questions for...
Thank you, Judge President.
Yeah, thank you.
Premier?
I'm also covered, CJ. Thank you.
Thank you.
Thank you, Premier.
Any questions, Commissioners? Commissioner Mqetho?
Thank you. Mr. Thupaatlase.
Commissioner Ngogai Toby.
Yes. Okay, I think
Both our
I
surnames are difficult.
I should accept the punchback.
Yeah, both
To
our
say,
surnames are
yeah,
difficult, Commissioner. Thank you.
No, I'm not sure if I heard correctly. What did you say to the JP? Did you say you agree with him that you are not ready, or you disagree with him? What was the actual answer?
No, the actual answer is that I think I'm ready. I can do that.
You are ready now.
Yes, JP. I mean, if you, and this is more fortified, for instance, by the comments that I got from the GCB and other law bodies.
Yes, and how many reported judgments do you have?
Reported?
Yes.
No, I only have published.
You don't have one. Yes, and you don't think that's a problem?
Commissioner Ngogai Toby, it could be.
Yes, all right. And then we've been looking at candidates who've acted for 60, 61, 62 weeks. And how do you fare on that one?
Yeah, no, I fare lower than them.
Yes. And we've also been looking at candidates who've been in practice. One of them was 36 years in practice as an advocate, particularly doing high court work, appeal court work, constitutional court work. And how do you fare on that one?
It is obvious that I fare lower.
Yes. Now, and these are the sort of core skills that this commission is looking at. And on those 3 yardsticks, you admit that you are below. But at the same time, you disagree with the JP that you are not ready. So
I'm just saying on the objective facts.
There's no problem of a self-assessment here.
Okay, no, I was just saying on the objective fact, just to say, you know, I was heartened by the fact that for what I've done with the amount of time that I've had, I didn't have any negative comments in terms of the quality of my judgment.
I mean, and most of this can be solved because you can get more time and then come back. It's not as if they're inseparable.
I agree with you.
Yes, so that's why I was just asking about the self-assessment.
I agree with you, Commissioner. Thank you.
Acting President?
Good afternoon. Thank you very much, Chief Justice. Good afternoon, Mr. Thupaatlase.
Good afternoon, Commissioner.
There are two objections. One is from, there's one from National Bar Council of South Africa. Their concern is that they don't think that you are ready because you haven't done you don't have any experience in constitution litigation. Do you agree with that statement?
From which association?
It's National Bar Council of South Africa. It's a letter that they wrote. Can't see the date here, but yeah, It's an objection that it's a concern that they've raised.
Yeah, it's that paragraph 4 there.
Do you see that? Paragraph 4.
Yeah.
Do you agree with that statement?
Yeah, the constitutional litigation specifically, yeah.
Do you agree with that statement?
Yes.
And then there is Law Society of South Africa. They are mentioning a complaint of bias. Did you see it?
Yes, Commissioner, and
You want to say anything about it?
after this came and I sent, this complaint was initially lodged with the DJP Sutherland, investigated the matter. He didn't find me any merit. Later, I got a call from the JP also, and I also responded. Some 2 weeks ago, I received a letter from this body, the JCC, the mini JSC, saying that the matter, the CJ referred a letter to JP Mlambo and also investigated the matter. The word used there is that he found it to be frivolous.
Sorry.
He found the complaint to be frivolous.
Oh, frivolous. So it was
Yes.
dismissed. Okay.
Yes. So what I'm saying is I'm the one who, if you look at my application, when I applied, I did when under the general heading whether there's anything that I wanted to put forward that may put the judiciary into disrepute. I specifically mentioned that to say, I'm aware of this complaint, the DJP had dealt with it, but at a time I had not received a feedback from the office of the JP. So that is where we are. So what happened is that on the 25th, 25th of September, the remarks were sent to me. But at a time, our network had crashed, so I didn't see these other complaints. But when I ultimately saw it, I sought advice from the office of this OCJ office, and I was advised that all that I did was to send the letter that had come from the JCC. So I thought that that response answered the issue that was raised.
My last question is, based on the nature and the amount of work that you have done at the Gauteng High Court,
Yes, JP.
how would you, on a scale of 1 to 10, how would you score yourself?
In a scale of 1 to 10,
Yes,
give myself 6.
6 out of 10. Okay, thank you.
Commissioners, on the virtual platform, do you have questions for the candidate?
Yes, I do.
Yes, Prof, go
Chief
ahead.
Justice, Mr T T Thupaatlase.
Dumela Rre Maruma, High Commissioner.
I just want to ask you about something that I've been thinking about in as far as civil work is concerned in magistrate court. I've realized of late that in the regional courts where divorces are done, most of the magistrates are reluctant to deal with maintenance matters that are incorporated into the summons where the divorce is actually sought. And this is mainly because the district court has a maintenance code. I'm not sure, what is your view on that? Is this not limiting these magistrates to be able to deal holistically with family disputes at a go and limit the chances of litigants spending more money by going from one court to the next. Because what I've seen is they tend to provide or to order a token maintenance so that the parties can later on go and fight their maintenance issue at the maintenance court. I'm not sure if you are aware of that and you have any views with respect to that.
Specifically, I'm not aware of that. There could be, and I take your observation, but I also agree with you that the ordering of token maintenance, which at the end now necessitates that a party must now approach the magistrate's court, really, in itself has an effect of delaying justice, if any. So where I sit, and because I know I'm in a training committee of magistrates, is something that I can take up to say, encourage magistrates, that regional court magistrates who are doing civil work, that they take a holistic approach of these matters.
That will really assist. Thank you very much, CJ.
Thank you, Prof. Well, thank you very much, Ndati. I'm scared to try to say your name. I suspect I'll damage it. Thank you very much for making yourself available for the interview.
Thank you, CJ.
You're excused.
Thank you.